Well, good afternoon, everyone. Thank you all for joining us for this breakout session. And you are the intrepid and hardy group to come to talk about data. It also shows how insightful you are, because this is actually the panel that really matters. It is. It is. I didn't find that wasn't the laugh line. I'll let you know when the laugh line comes. Sentencing and data are essential. They're also complicated, and they're a volatile mix. But without that, from our panels this morning, there were all kinds of comments that alluded to that. Judge Saris, former chair of the U.S. Commission, talked about, Judge Gertner. Judge Saris was not there. Judge Gertner talked about when we looked at some of the issues trying to create a commission, they didn't know what to turn to because they didn't have the data. And back in the book that brings us all together, and I feel like I should get a commission or something every time I show that, Judge Frankel thought about this relationship between what he called computerized information and sentencing. And he said, it's not necessary or desirable to imagine sentencing can be completely computerized. But at the same time, the possibility of using computers as an aid towards orderly thought in sentencing need not be discounted in advance. He says this does not mean that we're going to displace people by machines. The need for delicate and difficult judgments will remain for as long a future as is now imaginable. What will change, we might hope, is the uncharted expanse in which such judgments are now undertaken. We may hope to obtain some substantial degree of concrete agreement on concrete factors capable of being stated, discussed, and thought about in a style of a legal system for rational people rather than a lottery. We're again fortunate that the panelists with me up here this afternoon are true experts, visionaries in the sentencing realm, who have long wrestled with the role of sentencing information. We're going to dispense with formal bios because you have those pieces of information in front of you, so we're going to jump right in. Again, we'll start with some opening remarks from each of our panelists, followed by some questions and conversation. So with that, I'm going to turn to Judge Breyer.
Well, thank you very much. I'm really delighted to be on this panel for a number of reasons, but one of which is that it is entitled Sentencing Information for Modern Judges. And, you know, when you're 81 years old and you can participate on a panel for modern judges, you really feel that's just great. Keep saying it, and I may say it a number of times. This has been a tremendously interesting exercise, I think, for all of us to have participated in, because we started with continually return to Judge Frankel's book and his approach to sentencing and his dissatisfaction with the sentencing practices. A lot has been said that, gee, he didn't see this, or this was unintended, or this hasn't worked out, or this ought to be we ought to take these things into consideration. And I think all of that's true. All of that's true. But what happened in the first sentencing commission was pretty instructive as to where we are today, and something for everybody to think about, which is, as much as you may feel that you are wronged by the sentencing guidelines, or that the sentencing guidelines are imperfect, or the sentencing guidelines are far too restrained, or don't reflect the realities of the situation, you have to think of what would sentencing be like without any sentencing guidelines. And I think that when you go back to the first commission, when they got together and they tried to develop a sense of sentencing guidelines, they quickly found that by going around the room, they couldn't do it because there was no consensus whatsoever as to what I would say first, proportionality. That is this more serious than that? Is this worthy of more harsh treatment or more severe treatment, less amenable to rehabilitation? Any one of those things, they couldn't agree on that. The second thing they really couldn't agree on is, where should it be? Where should it be 10 months? Should it be 20 months? Should it be 50 months? And when you look at the sentencing guidelines, you see that and the sentencing that has to occur with judges. Judges have to figure out a sentence, and a sentence must consist of the consideration, by and large, of incarceration. And if it is interested and must consider incarceration, the question is how long? So, yeah, we're all in a numbers game. And the problem with numbers is one number sounds just as good as any other number, depending on who's speaking it. So I think that that the first year of the Sentencing Commission, we should never forget, whether their figures were perfect or not, what they decided to do was to try to look at experience. And in looking at experience, sorry, this is my telephone. Terrible. I always say that when this goes off in court, I always say, if that's for me, tell them I'm busy. And so I do the same thing here. So what they did, of course, was to look at past sentences and then try to create a grid out of past sentences that would then reflect some starting point for sentences. Now, two things happened. One is, and perhaps it was a basic miscalculation in the federal system, they thought that the sentencing guidelines would change over time based upon experience, and that if a particular guideline didn't take something into consideration, or should take something into consideration, or took something into consideration that shouldn't have been taken into consideration, or was too severe or too lenient, it would simply be amended. And it would be amended by the experience that people have in implementing these new guidelines. Okay, they thought that. The second thing they thought was that it's not really a problem to get an amended guideline through because, of course, Congress would have to enact a law in order to change it. Whatever the amendment was offered by the Sentencing Commission. Okay, that's what they thought. And then, of course, the commission over time decided that it was a terrible mistake to have an equivalency, a lack of equivalency, or maybe it's an equivalency, of crack and powder cocaine. And where one was 100 to 1, or what, I forget whatever the ratio was. And that when the commission tried to lower that disparity between the two, they couldn't sell it to Congress, and actually Congress overruled them. So the thought that it wouldn't be that it would be isolated or insulated from political considerations, I think was a miscalculation. Anyway, it is what it is. The system in the federal courts is what it is. We have a guideline system. We have a far too complicated guideline manual. But nevertheless, that's what the judges do. And I would say, somebody said it today, working under both systems, that is the mandatory and the advisory, judges and I think prosecutors and defense attorneys welcome the fact that it's advisory as distinct from mandatory. And so I think that has been a definite advantage. Now, the question is, where are we today? And in a sense, we're in the same place. You have the same practical considerations in amending the guidelines. But what we tried to do in the last 2 years was offer judges, defense lawyers, and prosecutors a new tool called JSIN, Judicial Sentencing Information. And what that did essentially was look at the sentencing practices of judges over the last 5 years for a particular guideline, particular offense level, particular criminal history, and tell the judge, the defense lawyer, and the prosecutor what judges have done in a number of cases, whatever that number is, as a practice, a more recent practice than what the guideline level shows. So in other words, if you have a guideline, it's at 60 months or 60 to 72 months, but the practice of your colleagues was to sentence 40 months or 50 months. That is one factor among other factors that judges can consider. And really all it is essentially, it's an additional data point, but it is an update of a sense of the sentencing guideline range, grid. So it tells judges today what the practice is today with respect to their colleagues. So that's a tool that has been developed for the modern judges. And interestingly enough, I asked Ken yesterday, what has been the incidence of use of this tool? And right off the press, he told me that since its introduction, it has been accessed some 28,000 times. Is that a lot? I don't know. 28,000 is 28,000. But it certainly is a number that is that's probably had some impact. Secondly, the Judicial Conference Criminal Law Committee has embarked on a pilot project in which certain districts have agreed to include that information in the pre-sentence report. So the judge has that information prior to the imposition of sentence. And certain districts have agreed not to include it. And they're going to see whether there's what the differences are with respect to sentencing practices. But that's the federal system as is. And when we met in our informal discussions, I said, I'm really interested in hearing what my colleagues have to say about state court systems, because I can tell you we looked at state court systems when I was on the Sentencing Commission, and they're quite varied. Their practices are varied. So I want to hear from my colleague about her system in her state.
Thank you. Thank you very much, Judge Breyer. Breyer, ready? All set to go. Well, good afternoon, everyone. My name is Tina Netto, and I'm from New Hampshire, very small state with only 10 counties. And I am the Chief Justice of the Superior Court, where we conduct all of our jury trials and major criminal cases. So if I could just see, how many of you are all judges in this room? One judge. Okay. How about prosecutors? Defense attorneys? Okay. And what did I miss? Anybody want to yell out? Professors. Excellent. Okay. Well, my view is that nothing undermines public confidence in the criminal justice system more than disparate sentences. And the question is, what do we do about that? I'm going to talk to you a little bit about the state perspective and also from a state that does not have guidelines. So maybe we need them, maybe we don't, but I'll give you some of my perspective about what I think ought to be considered in sentencing and what we should be looking at in sentencing and how I think we should be shifting a little bit from what was the charge to who is the person. And to do that, we need to look at all things about the person. We need to be able to assess the person and see what tools are going to best reduce their likelihood of reoffending. And I come from a little bit of a bias. I am a treatment court judge in a state that has treatment court in every county. And so what I love about treatment courts is they have actually been empirically studied for the past 30 years. They take sort of the profile of an offender who goes through treatment court and a profile of an offender, the same profile who goes through the prison and jail system, and we can compare sort of outcomes, which is what I think we need to be looking at. What are the outcomes? So one of the things I need to say up front is, in my view, there are a certain number of offenders that need to be in jail and prison and separated from us to keep us safe. But to be honest with you, that's a small percent. I would say about 20%. Here's some statistics, mostly from New Hampshire, because that's where I'm from. But I think in general application across the country, you probably will come up with similar statistics. And that is maybe 70 to 80% of people that we see in our jails and prisons are struggling with a substance use disorder and or a mental health condition. So the combination of the two. And we all see them come through our courtrooms over and over again because we aren't addressing the underlying cause, and we're focusing on the crime itself too much. So let me talk a little bit too about, you can see here the driving factors in criminal justice, that people with mental health issues and substance use issues are increasingly and overwhelmingly disproportionately represented in our jails and prisons for lots of reasons I could go into for another hour about what we've done institutionally around people struggling with these issues. But what I think is important in modern day sentencing is the ability to assess those individuals, because not every single one who commits a burglary or a theft or forgery or a simple assault or a robbery or even a second-degree assault or first-degree assault needs to be receiving the same response. We need to know what brought them there to get them to the courtroom in the first place. We see the sort of the first thing that got them there, but they are a book, and we are looking just at the page, and we need to know what the whole book is. And that's what assessment tools, if they are the right assessment tools and they've been validated and studies, can tell us about the person. And then from there, we can determine what level of supervision do they need. Is this someone that does need incarceration? Is this someone that needs intensive supervision with a treatment component? And those assessments help us determine more objectively and more methodically who belongs where in our criminal justice system. And I'm just going to say a word about jail, because in my view, if jail changed behavior or prisons changed behavior, they would be empty, and they're not empty. And we know, at least in New Hampshire, when someone ends up in jail or prison, they are reoffending at a rate of about 70% when they come out of jail or prison. If we do an assessment and we target what their risk level is, what their needs are, and we address those risks and needs, we see that people reoffend more likely at a rate of 30%. So this is just specific to treatment courts, so I'm showing you my bias right away. But treatment courts are designed to target somebody who is high risk for reoffending because they've got a lengthy record. They are high need because they have untreated severe substance use disorder or mental health issues. And when we look at that profile person, jail sanctions actually increase the likelihood of reoffending by a significant amount. So it's just an example to keep in mind. And then we can talk about, what do people learn when they're in jail or prison? We know that drugs are sometimes readily available. They're hanging out with people who are better criminals. They lose their job. They lose their housing. So there are a lot of collateral consequences that we need to think about. And I think in our country, we are trained to sort of think about jail and prison as the punishment. That is punishment. There are all kinds of punishments. We also know, probably you all know this already, that the United States has the highest incarceration rate of any other country on the planet. It is 5 times the worldwide average. And depending on which study you're looking at, it's either Korea or Russia, I think, that is a close second. But that tells us, are we looking at the right criteria for each person? Are we putting them in the right level of supervision so that we can reduce the likelihood of reoffending? And this is just I'm using a treatment court example, but you could use it for any kind of other sort of option for somebody. When you see at the beginning what happens when we put people in jail or prison, we're actually increasing recidivism by 8%. Community supervision by itself is kind of a wash. Treatment and then community supervision plus treatment. And when I say treatment, I don't just mean substance use disorder. I mean mental health issues, trauma issues, co-occurring issues, the things that we don't think about. I mean, when I started as a judge 27 years ago, I saw someone in court. I found out what they did. I thought about what their record was, and I decided what is the level of punishment they require. I didn't think at all about what is even trauma, and what does trauma do to someone's brain, and how does trauma affect somebody's ability to make decisions or choice around decisions. So, wow, that was it. I don't mean to go to the coffee break already, but that is my just sort of 5 minutes of intro from a state that doesn't have guidelines, but also from a state that is very interested in using data and evidence to determine how we can best manage our populations.
Wonderful. So we've gone from the federal system to a state system without the kind of structures that we've been talking about, to a state that has one of the oldest commissions.
There you go. Well, good afternoon. I'm Mark Bergstrom. I'm Executive Director of the Pennsylvania Commission on Sentencing. And to some degree, what I'll talk about is a combination of what Judge Breyer said and the Chief said. Pennsylvania is an indeterminate sentencing system, and so we still have parole. And the Commission was given the responsibilities sort of across the horizon of all decision points in the system, developing guidelines, and then trying to coordinate those guidelines. And I'd say just at the start that foundational is the use of data, collecting data, making sure it's complete and accurate and useful and meaningful, and that you can use it to try to answer questions that you have, whether it's about outcomes or it's about practices or other things like that. So talk a little bit about how this all fits together. Our commission was established in the early 80s. And so for a long time, our job was sentencing guidelines. And although we went sort of back and forth, they're effectively advisory guidelines. So Pennsylvania guidelines apply to both misdemeanors and felonies. Pennsylvania is a fairly large state, so we see 150,000 sentences a year. And so the guidelines were intended to provide that common starting point for judges. And the question is, how do you determine what that common starting point is? What's typical? Because that's what we were looking for. And we think about typical both in terms of the disposition of the cases, is going to be probation or county jails or state prison, and the duration. And that's true of all sentencing systems, I think, in terms of thinking about those two criteria. So in trying to figure out what is that typical sentence, the world of guidelines often talk about two different approaches. One is you're describing what's happening. And so if you're trying to describe what's typical, you need some kind of data to inform that. And so the more detailed you can be about the data, about the conviction offense or the elements of that offense or sentencing factors related to that offense, or whether that's a first-time offender or someone with a criminal history, the more detail you have that you can refine that information, the better you can use it to then say, oh, here's the typical sentence. So in the federal system, when the judge was talking about the new information available to judges to talk about what other judges have done, it's great to have an apples to apples comparison, that you're looking at the same cell or you're looking at the same offense with the same factors in play. So the more refined you can get, the more sort of focused you can get on describing that thing, the better you can then use that information to inform what you're doing. And so that's been our effort since the 80s of trying to continually refine what we're asking or what we're collecting and how we're analyzing it so that we can talk specifically about that offense and any other offense like it, because there's a lot of power in numbers. So, there's certain offenses that we have in our guidelines that we get a sentence every, 50 years on, but there's other offenses that you get, hundreds or thousands of offenses reported in a given year. And so it's those like big ends, those offenses that you have a lot of information on that you can really provide, I think, useful information to the field or to judges or to others that are using that information. So I just sort of talk about the importance of that information because that's one way of developing guidelines where you're trying to describe what's happening, where you're using current practices and you're trying to point that out to judges or practitioners and saying, here's what the distribution looks like, or here's the typical sentence. Now you do with it what you want in looking at this specific case. So it can be very helpful and informative, and at least our guidelines are built around that kind of approach. But the other thing to think about when developing guidelines is when you're trying to prescribe something, you're trying to encourage some kind of change in policy or the application of some policy, like the judge talked about in terms of a problem-solving court or treatment, where you're trying to promote a better practice. So I think guidelines in general try to take into account in some way both of those things, that descriptive information where you're relying on data, and then the prescriptive things that are much more policy driven, where you're trying to promote some kind of practice or implement some type of statute. So, so I just give that as background because I think the U.S. Sentencing Commission, the Pennsylvania Commission on Sentencing, and other agencies and organizations that sort of structure sentencing probably think in terms of those. And I point that out because I think that's a really helpful framework to then think about how are you using that information. The commission in Pennsylvania had that responsibility to do sentencing guidelines up front, but since then we've been given these other responsibilities. So we now have guidelines adopted for sentencing and resentencing following revocations of probation, and guidelines for parole and for recommitment following revocations of parole. And so the idea is to think in an integrated way, in an indeterminate system, about how you're feeding cases to state prison or county jail or to probation, and then what's happening once you have the cases in those systems. How are you dealing with violations? And what are those impacts on the criminal justice system? And what about parole? Who's being paroled and when and why? And what are the outcomes of that? So you need a really robust information system to be able to look at all these decision points and figure out what's happening. But the other part of this that's really important is then measuring outcomes. So being able to link information at sentencing to information about recidivism, about reoffending, or sobriety, or other kind of outcome measures that you think are important. Being able to connect the dots and then use that information as sort of a feedback loop about what works, evidence-based practices or data-driven policies. I mean, that's what it's all about, trying to make sure we have all the information to use for that. So I'll conclude with one other responsibility the commission has, and that was to create a risk assessment for use at sentencing. Those are like 10 years of my life I will never get back. But it was the most contentious process to develop a risk assessment for use at sentencing. But all the concerns we heard about development or use of a risk assessment were the same concerns we should have about data generally. You want to make sure it's complete. You want to make sure it's accurate. You want to make sure you're capturing the information that you need for whatever you're trying to study. Is it racial impact? Is it recidivism? Is it, what is it? You have to make sure you have it and that it's complete and that it's accurate. And that's your starting point. With risk assessment, the other big question was, how are you going to use it? Are you going to use this sort of general actuarial stuff to determine a sentence for this individual offender? Well, just like with our sentencing guidelines, this is advisory. What we're trying to do is trying to provide sort of a macro or top level information to the court for consideration. So in our use of risk assessment, which is, if you're familiar with risk assessment, a second generation, it's just focused on risk of reoffending. We use that and build that into our guidelines to recommend to the court those cases that may be worth a second look. It might be a second look because you're thinking about diverting this case from formal disposition, or it may be a second look not to say like prison over probation, but if you're going to use probation, what are the dynamics of that probation that would work best? What's the intensity of supervision? What's the duration of supervision? What type of conditions of probation would be warranted? And so our risk assessment just tries to identify cases so you can bring this to scale, so that you can say, here are cases that are worth spending a little extra time. Because at least in Pennsylvania, we don't have the time or the resources to do detailed pre-sentence investigation reports and risk needs assessment in every case. But if we can identify those cases where it's worth the effort, where there's a return on investment in those cases, then in those cases, more detailed fourth generation risk needs responsivity assessments can be done. And that's great information for the court to consider when sentencing an individual offender. So I think to sort of bring this to a close, this topic, this panel was talking about like risk assessment and talking about whether sentencing guidelines are still necessary to promote those ends. And I think both of these things can work together. And I think, at least we're working in Pennsylvania to think about this sort of holistic approach to integrated guidelines with assessments. Thanks.
So let me bring us back to Judge Frankel for a minute, and then with that question for our panelists. In the middle 1970s, after he wrote his book, Judge Frankel really kind of hit the road and would speak anywhere, anytime, in front of anyone on this topic of sentencing reform as he sketched it out in his book. And that included in 1976 a trip to my university, Villanova University outside of Philadelphia. And we in Pennsylvania listened to Judge Frankel. And in fact, our commission is, to my knowledge, the only sentencing commission to have adopted Judge Frankel's preferred terminology. It is the Pennsylvania Commission on Sentencing and not the Pennsylvania Sentencing Commission. Add that to your list of very useful arcane pieces of information. But at Villanova, he advocated for a full-time commission. And here's a brief excerpt from his transcribed remarks. He said, "Its most basic function, which is why I think well of it and hope it comes to pass, is to do something which no official group or agency has really ever done. And that is pay sustained, full-time, steady, unepisodic, unpublicized attention to the problem of sentencing. This would be its field. The ways it would pay attention include, among others, research gathering of information, dissemination of information, all matters of the first consequence in federal courts. I have to make a special investigation in my building," here he means, of course, the Southern District of New York, "where there are 25 judges, to find out what other people have given this year for mail fraud and so on. To me, it's a subject of interest, but obviously it's not of interest to other federal judges because it's not something that is regularly distributed. And I'm told it's not even regularly asked for because everybody does his own thing about sentencing, and whatever the other fellow does is his business." So obviously at the federal level, there's a change now with the development of JSIN. But let me turn first, Judge Breyer, to you. Why should sentencing judges care about this kind of information? When I read the little publicly available material on JSIN, the commission was studiously agnostic about, we're not advocating you use this, we're not advocating it. I see Ken Cohen's fingerprints on that language. It was, no, I'm teasing. But it was saying that here's this data, we're putting it out there, you do with it as you please.
Well,
why is a trial judge?
Well, all those warnings, those little black box warnings, doctors are very familiar with those black box warnings on medication. They were put on there for very good political reasons. I mean, listen, it was great being the Sentencing Commission, one person. I felt like I use the example of Miss Piggy in the Muppets, that it, like the commission, c'est moi, and the fact is that I was the only one. So I was saying something as the United States Sentencing Commission, a little dangerous, a little getting over my pay grade, and Congress would have no problem slapping me down on that one. But I want to go back to something that you've said quoting Judge Frankel, you can criticize the guidelines, and goodness gracious, I've never heard so many criticisms that I did this morning. One thing that you cannot criticize them for, the Sentencing Commission, is the gathering of empirical data. And if there's a central function accomplished by the Sentencing Commission, it is the taking of every single sentence and inputting it and looking at it from every possible angle in order to understand impact, to understand racial disparities, to understand recidivism, everything that you can glean from a pre-sentence report and a judgment and JNC. Everything that you can glean from it is actually incorporated in a statistical way in order to say something empirically about these sentences. Why is that important? Well, it's important for a variety of reasons, because judges can go on and on and on, which is what I do. But our time is limited. Our efforts are limited. Our energies are limited. So if you start to fuss about and spend time, countless hours, talking about something that's 2% of the sentencings in the United States, or in a case that, I was all exercised by a measure that was put in an application note. How do you gauge loss in a stock case in which something was concealed and then the information was later revealed and the stock fell or increased, whatever it was, fell by so much? How do you know it was the lie about the information that caused that particular loss? Because that then under 1B 1.2, that would be the measure. That would be the measure. And I went on and on why what was in there was ridiculous, it wasn't fair, and it wasn't accurate. And finally, the rest of the commission got so annoyed with me that they said to the staff, let's find out how many cases are actually involved. 4. 4. Actually, that caused me almost to be quiet. But it's important to have a sense of proportion. It's important to see what you can do and what you can't do. Because there are not only the magnitude of the cases, but then the practical political consequences of it. Could we change child pornography guidelines? Let's take one of them as an example. The child pornography guidelines say there's a 2-level enhancement, I think it's 2, for the use of a computer. Well, almost every, the days of where the guy in the raincoat says, "Psst, have you seen this?" That's really past. Maybe it still goes on, but pornography is disseminated on a computer. Why is it an enhancement? It ought to be in the heartland. Now, commission could take that on if they want to, and then you would hear, till the cows came home, from the Congress of the United States, we are soft on child pornographers. So that's why, if I have to say this, that because we have a substantial number of child pornography cases, that it's interesting to judges to see what their colleagues do in child pornography cases, which is in fewer than 30% of the cases do they follow the guidelines. 70% of the cases, they don't follow the guidelines. But what do? To say you don't follow the guidelines to a judge doesn't mean anything. What means something to a sentencing judge is, what do you do? What are they doing out there? That's why I'm a big proponent of JSIN, because I think it tells you that. Now, I am intrigued. I am intrigued by risk assessments. Because it's not a risk assessment is not a simple thing to figure out. And let's ask the first question. Is it important? You bet. There isn't a judge I know who sentences a defendant who doesn't have in the back of his or her mind, is this person going to recidivate? How dangerous is this person? If I say X and let this person out at X, Will this person commit a crime? Maybe I should say Y. Maybe I should say Z. So you really want to know recidivism. And that means to me that there's a lot of work to be done. And I do think states, by the way, are the laboratories of these sorts of things. And I would encourage the commission. We did look at Pennsylvania to find out as much about risk assessments as possible, because judges would love them. They would love them. The problem is, how do judges really know? How do judges really know, is this person going to go out and commit the offense again? Well, in certain cases, it's easy. But in the majority of cases, it is not. Now, maybe it's done by offense. Like there's a high level of recidivism for certain drug offenses. We have a high level of offenses. Is that true also with white collar crimes? But then you start getting real disparities and disparate impacts on different members of the community. Well, if you start looking at, does a person have a job? Does a person have a family? Does a person have an education? As to a white collar offender, the answer is yes, yes, yes. And therefore you don't send that person to jail because the answers are yes, yes, yes. And then you have a real problem in terms of public perception. Is the person, the African American, the Hispanic, the poor person, whatever it is, they're going to jail, but the rich person's not going to jail? And so they're complicated questions that the commission has to wrestle with. But that's another way of saying, give the judges as much information as possible so they don't just substitute their feelings as to what should be the sentence, and rather base it to the extent they can on empirical evidence, because that will, one, it will reduce, not eliminate, and maybe you don't want to eliminate disparities, because sentencing is always highly individualized. So you have to be careful that, that was the old joke about the Sentencing Commission when I was just started as a judge, and judges would get up and say to the commission, they'd say to the commission, the next time you do sentencing guidelines, don't call them guidelines, because they were mandatory. He said, all we are is sentencing accountants. We count this, count that, whatever it is. He says, you can't do that. Sentencing has to be individualized. So I'm not sure you want to eliminate disparities, but I do think you want judges to get as much information as possible. I think when you talk about violations of parole or violations of supervised release or probation, the commission has actually, I think, basically stayed away from that, not really going into it. Interesting whether they should or not. The interesting thing I've always found in the supervised release cases that I have, and we all have a lot of them, is, well, let's start out. First of all, Judge, you were wrong the last time. You have a failure. Didn't work, did it? Guy's right back in front of you. So you weren't so brilliant in the first sentence that you gave. And now you have to give another sentence. And every judge has a different practice. My practice is then I get the probation department really involved in it, because it's the other factors you want to look at. And it's why it's not working. And then I try to get the U.S. attorney and the defense attorney to see if they can get some agreement. The one thing I'm certain of, I don't know the answer. I don't know what's going to work, because I was wrong before, so I'm not so sure I'm going to be right this time. And that's the way I do it. Now, I don't know what that means. Does that mean every judge should do it that way? Of course not. Of course not. But I'm not quite sure it fits in the fabric of let's avoid disparities. As a matter of fact, I think it sort of cuts the other way. Let's try something different. Let's see if we can work it out this way, that way. So I may lose somebody on that one on this panel, but I think there's a big difference between initial sentencings and sentencing as a result of supervised release violations or parole violations. I'm also very concerned about parole agencies, which I think is, by the way, a very good thing that the Sentencing Reform Act got rid of, because I have seen how parole agencies operate in the state of California. And I have seen that it's highly political, that it's as much guesswork as anything else that goes on in sentencings, and it's highly uncertain, and it just doesn't work. So be careful of throwing out the guidelines when what you're going to substitute it with are the judgment of experts. I'm a little concerned about experts.
I don't know, I trust the three of you, but that's another story. What kind of access to individual case level data, like JSIN, if any, do you have in New Hampshire? And would you find it useful in the non-guideline jurisdiction?
Right. We don't have a whole lot of access, except there's only 22 of us, so we can ask each other how we handle typical cases. And so we get that information just sort of by word of mouth. And I would agree with the judge that you do want disparate sentences because it depends on the person in front of you. You might have somebody who's committed the same offense, but a very different profile person. Let's take possession of child sexual abuse images for one example. I see in state court a couple categories of those folks. One category are the 20-year-old males with autism. And believe me, that is an actual area of expertise where defense counsel learn how to represent those folks. They actually do rely on experts because sometimes I think it's appropriate. Sometimes it's not appropriate. Then there's a category of 40, 50, 60 somethings who are looking at child abuse, sexual images of very, very young children. So those two categories of people should be treated very differently. And some of it's based on what are other judges doing, and some of it's based on what is the evaluation of how this person will respond to our sentence. Are they going to come back to court and recidivate? That means our sentence didn't work, whether it's incarceration, whether it's not incarceration. So I think that we need a starting point. And I do think, for example, in New Hampshire, we have sentencing conferences where we come up with a bunch of different sentencing scenarios, and each judge reads it, votes anonymously what their sentence would be, so everybody can sort of see where we all fall. So I think some collection of data on what is the typical aggravated felonious sexual assault case? What is that? How are people dealing with that case? And then from there, how is this defendant different from that defendant? How is this defendant's background different from another defendant's background? And do we make adjustments for that? Because I think there's a place for both. What I like about the sort of sentencing guidelines are the collection of information that we can all use. The question is, are the judges who are issuing those sentences that are included in the guidelines educated about what works to change behavior? Because we could have one state where the sentences are really low and another state that uses the same guidelines where sentences are really high for the same behavior. And why is that? So I think disparate sentences make sense because we want to treat individuals differently. I think they don't make sense if it's because one judge is a harsh sentencer and one judge is a light sentencer when they've got the same case in front of them. So how we sort of manage those. And I think you're right. It's a combination of collecting that information and then doing a risk assessment evaluation to see what are the needs of that person to change their behavior.
So, Mark, you don't sentence people for a living. Not for a living. But you do it as a hobby? Is that yes. But you couldn't help it.
Don't know that.
But you support people who do through your work on the commission. And so can you speak a little bit to what the commission does to try to encourage the use of data by people in the fields, primarily judges, but also whether the attorneys, whether they be for the prosecution or the defense, also engage with the information that you make available?
Sure. So the commission has, I guess, effectively a dashboard that's available and has been available for years that provides pretty detailed information both at the judge level and the offender level regarding details of an individual case or aggregate information. And in Pennsylvania, our judges are elected. So it was another sort of contentious process of moving towards making this kind of information available. Because, the idea is that you can sit in a courtroom and provide all the details, but when the commission gets involved and we're aggregating things at sort of a higher level, you lose some of the context for sentences that are being imposed. And are there concerns about that? Do the benefits of it outweigh the concerns you'd have? And at least the direction the commission took was, we're an agency, the General Assembly, and so our job is to, we're using tax money to collect this information, to analyze the information, and we have a mandate to disseminate it. And there was not a good reason for not including all the information unless it's considered PII, private information, or personal information. So you can look at our dashboard in Pennsylvania and pick your judge, and I think contextually look at that judge or that sentence or those groups of sentences by that judge, by other judges in that court, by other judges of similar courts statewide as compared to that judge or for that offense or that offense with that prior record score. So, we wanted to provide as much detail as possible so that you could figure out what is that starting point. But as both the judge and the Chief Justice said, one of the, I think, great things about advisory guidelines is that they're committed to be a starting point. And I agree with both that sentencing is individualized. So I think out of interests of fairness and uniformity and proportionality, it's really important that we gather all of the information possible and provide a really clear statement about what happens in that type of case. And that might be what's the median sentence. It may be what's the entire distribution of sentences. It could be that sentence in this county. But I think providing that information is helpful not only to the judges, but to the practitioners and to others. And it also is helpful, at least in Pennsylvania, to our legislature and to our administration in trying to figure out what are policies that are worth revisiting or changing. When does it look like you have, huge outliers in certain types of sentences or really ineffective use of resources? We just went through a really long process of rebuilding our sentencing guidelines. And we took into account a lot of the things you heard this morning about reducing the weight of criminal history, really trying to cut back the impact of prior record on the sentence with the understanding that our sentencing guidelines, first and foremost, are a recommendation about that conviction offense. So we want to give an appropriate sentence recommendation. And the big change in our guidelines now are to be very much more targeted, that we target a specific type of disposition. Is it state prison? Is it county jail? Is it probation? And then the duration of that. In the past, we let judges, we had really broad ranges. So we had great conformity with our guidelines, but sometimes they were meaningless. So these new guidelines are really much more targeted. And I think that's helpful in terms of communicating to practitioners, to judges and others, sort of not only what the best practice might be, but also what is typically happening out there. And then allowing them to look at this individual case and decide what's the best thing in this case.
I really like how you say it provides a starting point. I think judges really crave that in my state for sure.
Yeah, and just on that point, especially when we have new judges or judges that had not worked in the criminal division coming over, having a common starting point is really helpful because they're clueless.
Right.
So we're coming near the end of the merciless hour, but I want to give an opportunity for folks in the audience to ask any questions.
Somebody has to explain to me how appellate review works. I remember judges saying, they were reversed. You always say if you're reversed, and if you're affirmed, you still think you were correct. The problem with appellate review is, of course, the panel doesn't look at the defendant. Doesn't. I mean, they don't have the person in front of them. They don't have any of the dynamics. What they do have is a statement, and they do, of course, have the law. And if the law is really misinterpreted, grossly misinterpreted, then of course you need to do something. But I don't. So I think there has to be some appellate review. But is the sentence reasonable?
Should data help inform
Yes,
that
yeah.
judgment of reasonable?
Well, I think it should.
And in New Hampshire, we
Does
don't,
it?
it
Yeah.
should, but in New Hampshire, we don't have any appellate review of sentences, if you can believe it. So as a result, the Chief Justice many years ago created a sentence review panel, which is still made up of the Superior Court judges, 3 of them, and either the state or the defense can file a request to review a sentence. And that panel would have everything that happened obviously in the sentencing hearing. And if people provided data, hopefully there'd be data, but it's really rudimentary in New Hampshire.
How often does that happen?
I mean, I would say out of, it's, I'm just trying to think back on some cases. Maybe we have 5 to 10 a month, which is not a lot at all.
I wanted to ask my co-panelists a question. What percentage of your cases are in terms of sentencing? Is a sentence actually determined by the judge as distinct from a plea deal? You
2%.
can't talk about a C plea in New York. They don't exist. The judges don't take them. But I think
It's a small percentage. I mean, maybe, between 5 and 10% is a generous number in Pennsylvania in terms
Of
of the
what?
judge having
The
exclusive run, because
Yep.
it's usually either negotiated pleas or recommended sentence recommendations. But the thing is that at least that takes into account that the guidelines are then used by the parties to reach that. So there's an indirect approach to that.
And furthermore, and this gets into the weeds of data in Pennsylvania, the way those are classified between being a negotiated and a non-negotiated plea is much more a matter of historical practice.
That's right.
But negotiated pleas includes Professor Altschuler's world, where, fine, we didn't agree on a sentence like a C plea, but I dropped 3 charges,
right.
and therefore you're being sentenced on this. So that's still going to be captured in that negotiated plea world.
Yeah, and just to sort of maybe close that out and relate it back to the data, one of the things that data can really help you think about is the attrition of cases, how cases move through the system. And so if you have really good information about charges as filed or even arrest information, and you can track those cases through your system to guilty plea or conviction and then sentence, that kind of attrition analysis is incredibly helpful in trying to understand these kind of practices and the role of guidelines or the role of statutes. And this gets to the discretion of the DA as well.
Right.
So I really had high hopes that in the hour we had together, we would solve all of these issues for all time. Turns out, not so much. So all I can do is express my sincere thanks to our panel.